breaking news is AH just went to court and lost big time. That's right, with a judge shutting down almost every argument that she had where she's trying to sue her own team. This creates some big problems for AH too. You and I, we are going to talk about all of that today. Man, fun times, huh? Fun times indeed. All right, so hey there to all you fine folks on this fine day. By the way, I hope you are doing excellently. So a judge just gave AH a huge loss on Monday, March 13th, 2023, wherein he told her that her main argument that she was presenting against her own team, the people that were paying for her lawsuit, that was going to be dismissed and it cannot be amended. Now, this is a huge problem for AH as she's still being sued in the aftermath of the Virginia lawsuit. If you haven't heard about this, the people that paid for the lawsuit, her insurance companies, one insurance company, they decided to sue the other insurance company, saying you didn't pay your part. The company being sued countersues not only the insurance company there, but also countersues AH. And AH's response is to try to sue the insurance company suing her as well, with AH claiming two things in her countersuit. This one, the first count, is the big one, and the one the judge, he wipes out outright. This is the main argument I want to present it to because it is such a terrible argument, but it's for breach of contract. And a second, which the judge says she can amend, and I imagine she will try to do this, but this is a very weak argument right here for tortious breach of implied covenant of good faith and fair dealing. Now, as far as that first claim is concerned, the one the judge shuts down outright, they'd already indicated that this was a very weak argument. They didn't see it carrying forward. And this is their strongest argument. What they're saying is after the trial, you know exactly how that went, so I'm going to skip that part, that AH, she had an insurance policy for all of that time. She started it up July 18th, 2018 to July 18th, 2019, meaning that when she dropped the op-ed, she already knew she was going to be sued. I mean, isn't that something? Now, as far as that policy goes, she claimed that she complied with all the terms and conditions of that policy, and she says, despite giving timely notification of the JD lawsuit and asking the insurance company to defend her, and the insurance company saying, they would defend her, she says they quote-unquote did not provide the full and capable defense to which she asserts that she was entitled to. They failed to pay the fees and costs she believes that they were obligated to pay, and best of all, she says, in other ways, they prejudiced her and her defense, aka she was blaming them outright for her loss. Now, the way that she says all of this happens, this is my favorite part of the argument, by the way, costing her hundreds of thousands of dollars in defense costs. And remember, that goes against what she was claiming in court, where she said she incurred $6 million plus in costs. Doesn't look like she was paying that. It looks like the insurance companies, they were the ones paying. But according to her, the insurance company here, they had reserved the right to deny coverage on the ground that she behaved intentionally. She acted with actual malice, which the jury found, by the way. asserts there that it creates a conflict of interest. Any lawyer that they would bring into this fray, they would serve two masters, essentially. They would be serving her. They would be serving the insurance company. She says that gives her the right to independent counsel, but with that right to independent counsel, you still have the insurance company obligated to pay for everything. Now, the judge points out the absurdity to all of this, saying, that lawyer that you're complaining about, the one you say that the insurance company picked up, Cameron McAvoy, Cameron McAvoy actually wasn't hired by the insurance company. herself already retained them before tendering the defense to the insurance company. So she hired this person. Then she decided after the insurance company signed off on them saying, yes, we will allow you to keep that person. They can represent you. Again, your own choice gets to represent you. She decided to phase them out for whatever reason. And they were saying, no, you don't get to do that. I mean, we signed off on your person. We don't have to continue to pay. Now, the best part about AH trying to pick this particular fight is the judge wasn't going to have any of this, and you could tell. Why? Because the judge had already ruled on this particular instance. And the interesting thing is that AH has done this before. Even though a judge has ruled on something, her teams, they come in, they argue the point, they try to overturn it. They did it in LA, they did it in Virginia as part of the Virginia trial, and it was always shut down. So this continues that losing streak. Listen to this here, though. This court has already decided that issue. So straight up, that issue, we already determined it, albeit in a lawsuit to which AH was not a party. Now, when it said not a party, she is part of the overall litigation, though. See, the court already determined as part of litigation between Travelers and New York Marine. That is the insurance companies we were talking about, 1 versus 2, where they were going after each other, that because the JD lawsuit was preceded in Virginia, and because New York Marine, that's the insurance company that's going back and forth with AH, provided AH with a Virginia lawyer, there could be no conflict of interest. Now, AH and her team get to go before the judge on March the 13th, and they make their argument. You know, they're supposed to try to sway the judge and say, no, this is a good one. You didn't see our point of view. Well, on the 14th, the decision comes in. It says, nah, we're going to shut you down. I mean, listen to this. We will get the minutes on it, by the way. Those will be really fun to go over, too. But hearing held before a judge. Oral argument is held. Now, the tentative ruling, that's where the judge was saying this is a terrible argument, is adopted as the court's final ruling. So the judge says that it's not going forward. That was their strongest argument, by the way. So they're in a lot of problems here. The court will dismiss the breach of contract counterclaim, likely without leave to amend. That means over and done with. You don't get to resurrect that thing. Oh, that is buried deep in the ground. And the court will dismiss the second part as well, but you have leave to amend. So you can try to resurrect that thing. She will, by the way. We're talking about 7 figures on the line here, plus her team. They are still coming after. They are still suing her because of this. Oh, man. I mean, you are talking about the aftermath being just as interesting as everything that went on. I mean, here is another loss. But anyway, let me know what you think about this. And as always, I appreciate the heck out of you. You make this stuff work. Thank you. Can't say that enough. Want to help the channel out, by the way. Share this. Make sure you're subscribed to, and check out the links in the description. But you being here, appreciate that so much. Thank you. Going to end here. See you soon.